Good morning. Okay, now that Dean and Jim have warmed you up, we're going to talk about some real fun stuff. I'm Phyllis VACo. I'm General Counsel for the Virginia Association of Counties, and I'll tell you a little bit about myself. My entire legal career has been in state and local government. I started my career many years ago in the Attorney General's office. I won't tell you who is the Attorney General then, because some of you would say, I don't even know who that is. Went on to work in the county attorney's office in Hanover County, and then many years in Henrico County, and then I've been with the Virginia Association of Counties since 2002. And for me, this is the perfect opportunity to use all the skills that I've built earlier to serve really the whole Commonwealth of Virginia. So it's a position that I really enjoy very much. I have an undergraduate degree from Lehigh University in Bethlehem, Pennsylvania, and my law degree from the T.C. Williams School at the University of Richmond. My colleague today, my co-speaker, is Maria Everett. Maria is the Executive Director of the Virginia Freedom of Information Act Advisory Council. She's also a senior attorney with the Division of Legislative Services, and I have to say a big thank you to Maria for being here this morning, because talk about it being your busy session. She drafts many of the hundreds and thousands of bills that we will be seeing in the General Assembly. So she's been working some really long and hard hours for really the past few months. And for her to be here on a Saturday morning during a time where she has no free time, I think really says something about her dedication to what she does and her commitment to assisting all of the citizens and the elected officials of the Commonwealth of Virginia. And Maria has been the Executive Director of the FOIA Council since its inception in 2000, and has been with Legislative Services prior to that. And really, her whole legal career has also been in the service of government as well. We've known each other a really long time. Maria attended Virginia Tech undergraduate and George Mason Law School. And we're going to talk today about two of the three mandatory things you have to know. You have to know so many things to be able to be an effective elected official in Virginia. But there are a few that the Virginia Code says you're required to know. Those are the Public Records Act, the Freedom of Information Act, and the Conflicts of Interest Act. So we're going to talk about the first two, public records and freedom of information, this morning. And then we're saving the best for last, conflict of interest, tomorrow. Always an interesting issue. So why do I say that these are the mandatory things? Because the Virginia Code says that each elected or re-elected or appointed or reappointed public official shall receive a copy of these statutes and shall become familiar with them within 2 weeks of their election or appointment or re-election or reappointment. So I know that you've all seen these things before, correct? Yeah, everyone's nodding, that's great. But you know, it's really hard to really understand them until you get into the practice of using them. So it's a whole, I mean, it's interesting. When I'm learning something new, I try to think of how does this relate to my life as I know it now, so that I can understand and transition into how I'm going to use it in my new role. So the Public Records Act was enacted in 1976, and the purpose of the Public Records Act is to develop a uniform system for the maintenance, organization, and even the destruction of public records. So when you think of that, it's just like in your home life or in your work life, you have to have some system to organize those things which are important, your important stuff, your important records. What's the method that you organize those things in your home, whether it's your bank statements or other documents or in your work life transactions and that sort of thing. Exactly the same thing. This is the act that says, public officials, here's how you organize, here's what you have to maintain, here's how long you have to maintain your public records. So when you think of it that way, it really does make a lot of sense. And again, it's meant to be uniform. So I would say this is an act that helps you. Is it easy? No, nothing good is ever easy, but we'll talk about the difficulties in your application of it in a moment. But the Library of Virginia is really the entity that oversees the Public Records Act. They are the ones that the law gives the authority to establish how do you maintain, how do you organize, how do you dispose of, and that includes all state agencies, all local agencies, all regional agencies, so they are the ones. It's the Library of Virginia. And there's a copy of the code, even though I know that you got it within 2 weeks of when you were elected. There's a copy of the code section in your notebook today under tab 2. I will also say, in case I forget in the end, the Library of Virginia has a really, really good website for those of you who enjoy looking at things electronically more than they do paper. They have so many resources on what is a public record, how do you manage the public record, how do you plan for disasters. All this information is on the website of the Library of Virginia. They also have people there who can provide technical assistance in case you're confused about what you need to keep, how long you need to keep it. They have people there that can help you. And they, along with Maria's organization, do road shows throughout the year to talk to folks, and they go out into the Commonwealth about public records. I think that it's important to sort of talk about how did they get there. Well, the Library of Virginia, once this act was passed, really took a survey of what are all the public records that are out there. And they had to look at every agency, every locality, every public body to determine what do you deal with on a day-to-day basis so that they could sort of categorize them and work with people from all these stakeholder groups about what is the importance of that document, what is the administrative, the fiscal, the legal importance of that document, and how long do you need to keep that document so that you can get your hands on it. And the Public Records Act is for you as public officials so you can organize things, but it's very much for the public as well, so that they can have access, and when we talk about access, Maria will talk in a few minutes, to those important government records that document those transactions that you, their officials, are participating in on their behalf. So it's really for everybody that we preserve these public records. So I think it's important to look at what is a public record. And I'm simply going to read from the definition because I think it's really important to understand exactly what we're talking about. So a public record or record means a recorded information that documents a transaction or activity by or with any public officer, agency, or employee of an agency, regardless of physical form or characteristic. That's important. The recorded information is a public record if it is produced, collected, received, or retained in pursuance of law or in connection with the transaction of public business. Transaction of public business, that's what you need to keep in your head. The medium upon which such information is recorded has no bearing on the determination of whether the recording is a public record. We're going to talk about that a little bit later, but what that really means is just because you do it on your personal device doesn't mean it's not a public record. We're looking at the context of the record. Does it involve the transaction of public business? And if the answer is yes, doesn't matter what the medium, where it is, how you created it, it's a public record. So that's really important in today's technology savvy world. I just want to sort of give the flip side of that. A private record means a record that does not relate to or affect the carrying out of constitutional, statutory, or other official ceremonial duties of a public official, including the correspondence, diaries, journals, or notes that are not prepared for or utilized for or circulated in the course of transacting public business. So the flip side is, let's say your locality provides you with a smartphone or a computer or a tablet, and you make plans to meet a friend for lunch on that device. Now you have to look at your individual policies about using official county property, but that kind of a thing is not a public record, even if you're using public equipment or equipment that's been supplied or paid for by the public entity. It's still not a public record if you're making a date for lunch or something that does not involve the transaction of public business. So it's really important that, I think as you get into your duties, everything you do, you sort of need to do a check in your mind, public business or private business, as you're transacting, because then whatever you create is somehow going to need to be organized and retained later on. So that will help you if you get in that mindset. So how does this relate to localities? Well, so the Library of Virginia then has gone through this surveying, and they have determined there are, and I'm just picking a number, 2,000 types of records that local governments deal with. They have then put them into schedules, and the schedules have titles like, well, I have some examples here: general administration, local departments, human services, judiciary. There are actually 29 schedules right now that deal with local government records. So you may pick up a schedule like general administration. Most of your documents, you in this room as elected public officials, are going to be under general administration, because we're talking about things like your correspondence, your public calendars, that sort of thing. And they're going to be in Schedule 19, which is general administration. Like I said, there are 29 schedules, but you go into that schedule and then you say, okay, I've got correspondence. How long do I need to keep these? And you will look in that schedule and say, okay, here's a category for correspondence. I need to keep those for 3 years. And so there is a line for every type of document. If some new type of document or new type of record appears or becomes frequent, the library will revise their schedule and add it. It's an ongoing process with the Library of Virginia in developing and revising these schedules, so they make sure that you have the guidance you need to know what you need to do with those public records. So these things are being, I don't want to say constantly modified, because they're not changing them all the time, because that would be confusing, but they're being looked at by the Library of Virginia staff. They are interested in hearing from you all if the schedules don't make sense or are cumbersome or are not capturing what you have as records. They frequently contact us to sit down with them to help, because many times we get calls from you saying, this does not make sense to me at all, or I don't know where to put this. So we're in touch with them on a regular basis saying, to help the localities, we need another category, or we need to condense categories, because you have 6 categories that talk about the same document. And over the years, they've actually reduced the number of schedules based on these meetings that you all and we have had with them, saying, now you're making it too complicated. And they're very responsive, and they have a very, very good staff there that is devoted to preserving public records and making it easy for you, because this is not easy. And I'll tell you, the difficult thing for you is email is wonderful, and we all love it because it's a quick way to get information back and forth. But I think one of the more difficult things for public officials to manage in the past few years is emails, because emails are public records when they address the transacting of public business. And so what that means is you have to keep those emails for whatever amount of time that the Library of Virginia's schedule says. So most of them are going to be correspondence type things, and those are going to be 3 years, which means every email you get or you send that involves a transaction of public business has to be kept and filed. And so you need to maintain some kind of system to do that. Now, each locality is required under the Act to have a records manager. And in smaller localities, that may be the county administrator. In larger localities, some even have a department of records management. But each locality must have a person or persons that are designated as a record manager, because that is the liaison person with the Library of Virginia in terms of helping to determine how do you keep and maintain those files. They do other things like help you prepare for disasters, flooding we've had, that sort of things. How do you keep your records safe? Many new things come up. How do you maintain your social media? Because social media can be a public record if it involves the transaction of public business. So it gets more complicated as technology gets more sophisticated. But that records manager is your liaison with the Library of Virginia to help you make sure that you conform to these, the law. The actual schedules themselves are regulations that are put out by the Library of Virginia in conjunction with stakeholders, but the actual Public Records Act is the law, and it is a requirement that you keep these records. So now that you have these public records, the next thing to think about is how can people access these records. So I'm going to turn over the podium, or if she wants to sit, to Maria Everett, who's going to talk about the Freedom of Information Act. We have a question.
Yes, would you clarify the non-public record just a minute, if you could, please? If I'm sitting in a board meeting and we're having a public hearing, Mr. Jones speaks for something, Mr. Smith speaks against it, Mr. Williams speaks for it, and I'm sitting there jotting down Jones for, Williams against, Smith for, does those jottings then become a public record?
They could be a public record because you're making notes of a transaction, but I will say that the primary public record there is going to be the clerk's minutes. So that's one of those judgment calls. I think probably not, because the minutes of the meeting are going to be the public record of that transaction. But it would depend. You may have other things there that are not included in the minutes, so you sort of have to look at them on situational basis. Yes.
My question is on this idea of it documents a transaction. Obviously, transaction being a term of law, what exactly does that mean to me as a board member? If I'm having correspondence with a constituent, as an individual board member to an individual constituent about an issue they're concerned about, is that a transaction, or is that just me responding to them and doesn't count as a public record?
Well, I'll answer and then I'll let Maria answer, because these are things that reasonable people can differ. I think that is. I think the person is corresponding with you because you are a public official, not because you're their neighbor. So I think that is a public record. Maria?
I was asked recently if texts were public record. I didn't know the answer to that.
I didn't hear you.
Texts.
I was asked recently if texts were public record, and I didn't know the answer to that. How's that preserved?
Yes.
I'm going to turn it over to Maria. She gets these questions every day because they're a resource.
Good morning. Scared yet? There are different answers depending. I'm the FOIA person. I'm the access to public records person. And the Public Records Act is a little bit different, but essentially the definition of a public record is the same. Texts are public records. How are they retained? That your phone retains them. There are software programs that are capable of retaining them, and you have an obligation to do so. I want to start sort of general and then leave some room for questions, because you think, okay, geez, I'm going to listen to FOIA at 8:40 in the morning. You're going to be surprised that you're going to be alert through all of this, I promise you. First, let me welcome you to public service. For those of you in here that have this idea that there's some glory about this, you will quickly be disavowed of that notion. Public service is a thankless job. People in the audience, they may ridicule you, you know what I'm trying to say, but no, deep down, they're thinking, thank God it's them and not me, okay? So to me, the only more thankless job there can be is be a board member on your homeowner association. So I just want to disavow you that you all think as Dean said, you're leaders in the community. Well, you may be, but you have a big fat target on your back, okay? This is thankless. I just want you to disavow you of any notion of this is sort of, whoa, this is going to be great. It's going to be hard. Public service is a tough and not for the faint of heart. So I want to welcome you to the most public stage of your life with 360 mirrors, and the women in here know what I'm talking about. Your backside is exposed as well. Public service, like I said, is not for the faint of heart. Most people get involved in local politics because they are frustrated with the way things have been going on in their locality. At the General Assembly, we have a saying, don't become that which you sought to vanquish. Somehow, when you're sitting in the audience, this looks all pretty easy. And when you're at the dais, things change. And somehow then you start going, oh, well, let's take this quietly. We just want to talk frankly among ourselves. There is no frankly in the FOIA world, okay? There is public discussion, deliberative bodies, school boards, boards of supervisors, city councils, General Assembly committees must deliberate in public. That's the idea. Period, end of conversation. Now, there are exceptions that you allow you to close a meeting to public discussion to allow some more frank discussion where we're protecting a bargaining position, a negotiating strategy, or we're protecting the privacy of certain personnel. Those are the only times. So it's really easy, the temptation is, this is controversial. It'd be really nice if we could just like go over here and meet over it, you know, the abandoned warehouse, and nobody will have to know. Wrong. So just setting the stage. To tack on with Phyllis, we do the annual FOIA Roadshow, and for those of you new to FOIA, Freedom of Information, look what we've done to it. It's FOIA. Have you been FOIA'd? It's a verb. Is it FOIA-able, an adverb? And actually there's a song from the 70s or 80s, Johnny Guitar Watson, and when you look, you will discover that it's a real mother FOIA. And you will find that to be true. In your materials, we have a toll-free number at the FOIA Council. We are a state agency, so call us. That's our job, to give you advice. And when we're not doing the roadshows, we will come to you with just based on invitation. If you want us to come down and talk FOIA with you and your staffs, we will do it free of charge. So just a few things. The freedom of information means different things to different people. And nobody mostly has it correct. Even me sometimes. But we all have perceptions of what we think this law means. So today is about what does this law mean specifically and what does it mean for you. So again, we'll talk about the meeting side of FOIA as well as the open record side of FOIA. FOIA is the promise when you think about government of, by, and for the people. What does that really mean? And none of us really can come up with a quick answer. FOIA is what it means. If it's truly our government, then we, the people, have the right of access to everything the government is doing because it's all for our benefit. Okay, so public record, generally anything, regardless of physical form, as Phyllis said. Text, if it meets this criteria, it's owned by us, it is prepared by us, or merely in our possession as it relates to the transaction of public business. And so you have to broadly construe what public business means. I have chiefs of police that always say, Maria, this notebook is just my personal notes. Now, I'm a cop's daughter. Talking smack to a cop is just not in my DNA. But I say, you know, Chief, let me tell you, unless those notes say, pick up dog food, eggs, and bacon on the way home, it is a public record if it has anything to do with public business. And as Phil says, people text you, they write you, they correspond with you, they tell you things like, you know, my husband's in prison and my son's in Judy Hall, but they're contacting you not because you're their neighbor, because of who you are, because you're a member of the Board of Supervisors. So then it automatically falls into the Public Record Act. Anything owned by us, prepared by us, in our possession. Sometimes we share public records in the transaction of public business. So that's a very broad definition, so everything is. There are 135 exemptions from release under FOIA, and you might think, wow, that sounds a lot like Swiss cheese. But it's not. What it does is FOIA recognizes there are times in all of government's lives that we may need to hold things close to the vest. And it's always in the public interest. We're negotiating contracts. We don't have to give out contract documents if we don't want to while we're in the negotiation stage, because whose position will be damaged? The public's position. Whether we're in litigation, a bargaining position, we're working out a water deal with a neighboring locality, whatever the circumstance, we're getting legal advice. So FOIA recognizes there are times that we can play it close to the vest, both on the record side of the ledger and on the meeting side of the ledger. And it allows us to do that, but it's through a process. FOIA is nothing but a process which says people have the right to request records. FOIA doesn't require any of us to put anything online. It's all generated by request. And then we have to act in a certain time period, 5 working days, and we have to provide written responses. Now, most of the localities, the county administrator, the executive, they handle the FOIA requests. They may come and ask you for particular records of which you may be a custodian. And Phil is completely correct that in FOIA, as in the Public Records Act, the equipment you use has no bearing on the record. It's the content of that record. To the extent it has anything to do with public business, it is a public record. Now, we as human beings tend to commingle things. I've seen emails that say, well, gee, I was at the ball game last night, and I'm in an email. I'm at a ball game, and something about eating hot dogs makes me want to drink beer. So you go on down this road, and then they get to the public business. So then the question is all of that public? And the answer is that first paragraph has nothing to do with the public business and can be taken out of the record. But the paragraph that gets down to, have you done the research on this? Here's my analysis of this question. That's the public record part. So your home computer, your personal business computer, if you're conducting public business on it, it becomes subject to FOIA and you will have to produce it if requested. And just a word, for those of you that have to at some point produce records of your own that somehow the locality does not have, you cannot charge your business rate So if you're a physician or a dentist or a lawyer and you're making $225 an hour, you're not charging that to the citizen, okay? We've had that. The examples I use are not new. These are all questions that come to us at the FOIA Council. Email, I have a different opinion of email. I have a whole presentation generally, which is email bad. It makes us incredibly lazy. We say things like drinking beer and eating hot dogs in them, and we think of them as some ethereal thing that goes away. And so we do it a lot because it's convenient. It's not necessarily the best choice, always. So think about things like in a text message or an email. If the reader has to scroll to read it, then consider a different method of communication. Because in FOIA land where I live, words can never hurt you. Written words can, to the extent they relate to the public business. Again, that public stage. I want to switch over into the meeting side of FOIA because the records world applies to everyone in government. The meetings law of FOIA applies only to deliberative bodies, boards of supervisors, school boards, members of the General Assembly, committees, public service authorities, you name it, any sort of deliberative body. And the guarantee under this law is deliberative bodies must deliberate in public because how you arrive at a decision is just as important as the decision itself. And the guarantee is to allow every citizen every opportunity to witness the operation of government. So they get to be in front of you, watching you sweat, if it were. And again, saying, I'm glad this is not me. I could criticize them, but you know, I don't have to make this call. So in the meetings world, we need to know what the heck, how do we know when we're having a meeting? And most of us kind of get it when we're sitting there at a meeting called and we're sitting at the dais, the full body, that's a meeting. Okay, we get that one. But FOIA tracks down to much smaller numbers, which says anytime 3 or more of the members of the same body, elected members, staff never counts in the equation. Anytime 3 or more of you at the same board members of the same board meet together informally and merely discuss public business, it is a meeting. So when you got elected, in addition to like a mountain full of paper that said, you gotta read all of this and actually know it, you got a tattoo across your forehead. You didn't feel it, did you? But anytime 3 or more of you gather in the name of public business, your tattoo not only becomes visible, it starts beeping, okay? The 3 or more rule. Let's look a little bit at how that can happen. I assume all of you have been sworn in by now, right? Is that true? So yeah, no more members elect. How did you get here? Did 3 or more of you drive in the same car? And what did you talk about? Because under FOIA law, 3 or more, the right number, and the right discussion, it needs both. So 3 or more of you can be talking about your golf game or how cold it is outside. It's not a meeting because you're missing the discussion. I work for the General Assembly. Thank you for not throwing anything. And I say this in all sincerity, trying to tell elected officials to keep their mouths shut. What do you think the success rate of that is? Not very high. So FOIA gives you choice, 2 by 2. We call it the Noah's Ark rule. 2 by 2, you can have discussions with your co-board members, 2 at a time, and it's not a meeting. Because what FOIA is trying to do is say, we want you to percolate about the public business that you voluntarily put yourselves into, right, with the help of the public. We want you to think about this stuff. We don't want decisions made when you're sitting at a dais. You know, we want deliberative process. And so again, this is a balance against the need of government to function against the right of access. So hence the Noah's Ark rule, 2 by 2, you can discuss public business without the public being there, without minutes, without notice, all you want to, okay? The only exclusion to that is if you're a subcommittee and a quorum of that subcommittee is 2 people, the Noah's Ark rule does not exist because it's a quorum of a subcommittee, which is enough to transact business. So again, you have to have the right number, 3 or more, same body, and the discussion. And we've already identified we're not going to be able to keep our mouths shut. We've got that. So keep your numbers low. I'm not trying to tell you how to get around the law. This is what the law allows. Again, in the name of deliberative process. The Noah's Ark rule can be applied in different ways. You can do it by phone. You can do it by meeting at the Burger King. You can do it in person. And you can do it by email. But be careful. The consequence of your choice to use email is what? You are documenting public business. And it will have the date and time this happened, and you will document your own violation. So think about the consequences of choice. Let's explore 3 or more a little further. Does anybody ever think about it? I mean, I know you're new. Come early to a meeting. 3 of you are discussing the agenda with staff. Who thinks you're beeping at that moment? Me. Everybody else, raise your hand because you are. Okay. After the meeting, it's adjourned. Boom. People are walking out. 2 or 3 or more of you are sitting there walking out to your cars, talking about what you just did. Who's beeping in the room? Yes, it's still a public meeting. People say to me, but Maria, there were 3 of us, but I never said a word. Okay? Your laughter tells you. You were in the presence of public discussion. The rule of 3 or more. You may be traveling to look at an economic development site. You're in the car, 3 of you. The temptation to talk shop is great. Somebody in the car has to say, I don't think we should have this discussion. Now, this is really a public discussion. Then everybody will throw their Coke cups at them and say, oh, come on. But I have a safety valve for you. When you're in a carpool situation and there's 3 or more, like when you're going to come back here for legislative day at the General Assembly, I guarantee you will carpool. Keep your mouth shut. Or this is the fail-proof way, because if it's a meeting, it requires notice to the public. It requires it to be open, and it requires minutes. Okay? So somebody in the car say, well, who's going to be taking the minutes? And I guarantee you, nobody will talk public business from that moment on, because nobody wants to take the minutes. Okay? So the rule of 3 or more, it could happen in church. You go to church, you're in the same community. After the sermon, you go have a cup of coffee. Unless you're talking about, wow, what a great sermon that was this Sunday. You could talk public business in that arena. Don't use that as an opportunity to discuss public business. So it says the informal gathering of 3 or more makes it a public meeting, which has to be open. And like I said, when you use email, you do document the fact that you are meeting outside of the public domain. Now, lots of things. FOIA, remember in the 70s there was a song, whenever 3 or more are gathered in the name of love, you know. FOIA world, whenever 3 or more are gathered in the name of public business, there is meeting. And FOIA further says, failure to follow any procedure. You don't give notice. It's not open to the public. Minutes are not taken. Is deemed a violation of the law. And you can be sued on that basis alone. And the person who sues you doesn't have to prove anything. All they have to allege is they violated my FOIA rights because on this economic development issue, they kept meeting secretly with the developer and never noticed the meeting, never did anything. So be careful, 3 or more and the right discussion equals meeting. But in the 3 requirements of notice, open to the public, and minutes, you do only one of those things. Your staff does the minutes and your staff does the notice. So it's incumbent upon you to comply with one provision, which is make it open. Again, do not become that which you have sought to vanquish. All right? So you can see the rule of 3 can happen. You're out playing golf. You happen to be walking down the street and see two others. The opportunity to talk shop is great. The meetings law is the true integrity in government component, I believe. So you have to say, why don't you walk away? Now, I commend to you the State Council of Higher Education. We worked with them, and they had a video produced for the Board of Visitors, but it applies across the board. So in your free time, this is the end of your free time. Just want to make that clear. Look on the Chev work site, or you can come through the FOIA Council work site, and it's a 10-minute or an 8-minute video that essentially says, you're not in Kansas anymore. For those of you who are used to private sector boards and how that operates, that does not apply over here in the public service world. And so it gives you examples of everything I've said about as long as you're talking about the weather or whatever in groups of 3 or more, you are fine. But use that as an opportunity to talk public business. You are violating the law. And further, if you use email, it will document your violation. And then what happens? They can sue you on that basis alone. They don't have to prove anything. The burden of proof is on the government to prove they complied with this law. And when you have an email date stamped where there's discussion among 3 or more members in real time, you've just documented your violation. So now what happens? Well, bad press happens. We already know that. But now the person who sued you to make you do what the law already requires you to do is entitled to recover their attorney's fees and costs. Who's got money here to give to people who probably we don't like in the first place for mistakes we're making? It makes no sense to me. Now, while I'm on the topic of email, the question is, clearly email can be a public record. FOIA is not a retention statute. FOIA just says if you have it and somebody asks for it, you have to go through production drills. But on the record side, on the meeting side, can FOIA be a meeting? Email be a meeting, I'm sorry. And the answer is yes. The Virginia Supreme Court has so said that anytime that 3 or more little rule, anytime you are talking in real time, whether it's a chat room, whether it's texting, it's the functional equivalent of being in the same room at the same time. That is a meeting under FOIA. So look at how many rules you're violating. Not rules, this is state law. And again, your email will document your violation. So our advice to you, we have lots of handouts on our website about handling of emails from a records point of view, but also email as a meeting, how to keep yourself out of trouble. Our first suggestion is never, ever use reply to all. That starts it. If you watch the Weather Channel like I do, you learn about how lightning works, and it's like a bunch of static electricity starts lining up, and then it gets grounded to the earth, and then same thing with email and meetings. One of you send out, I read this really great article, just want you to know. Then somebody, because our need in this age of information is, I want everybody to know what I'm thinking at the same time I'm thinking it. And we all share that. So somebody gets this thing, and you don't mean for anybody to respond, you're just pushing something out. But 2 more members get right on back to you and say, no, I read it and I thought it was great. I think we could do, you see what happens? The static is starting to line up, and then 3 of you are in real time talking about public business, which now you are documenting. You have the lightning strike, you're having a meeting. So reply to all is not a good thing. One of our suggestions is send it through your staff so that they can moderate the time that between, because did the Supreme Court say 15 minutes is okay? No, it said simultaneous communication. And so we don't know. So you have to think in terms of, is this a real time as if we were sitting in a room? And certainly technology allows us to do that. So think first about that with email as a meeting. So again, the rule of 3, anywhere it happens and the discussion equals meeting. And if you haven't had notice, and the rules that I'm talking about also apply to any subcommittee that you create. They are a public body under FOIA, so notice, open, and minutes have to be made of every subcommittee too. All right? And then, yes, ma'am.
I just want to confirm, in a situation like that, coming from the school board side, we were very, very careful. And I just want to confirm that if somebody hits reply to one and then CCs the rest of the people, it's essentially the same thing, correct?
Yes, I think functionally, but what you have to have is that the CCs, 3 people are online all at the same time, chattering back and forth electronically.
Right.
So I would avoid, you think that's a good example. Well, I'll just put one other member in the to line and then CC the rest. You haven't functionally done anything differently. If the result is, that alone did not put you in violation. It's when everybody starts, the 3 get on texting or online or emailing at the same time.
Or if you have the two members and CCing the rest, you're already in violation.
You could be, but it takes the next step of those other people that are receiving it to do something affirmative, to have a discussion in real time.
Absolutely.
That's
Okay.
why we say avoid it, because it can lead to no good. Yes, sir.
How much time would intervene to get around the simultaneous?
You know, I got no answer for you because the Supreme Court, but simultaneous, when you think of, is this the functional equivalent of us sitting in a room? I think just avoid it because it can't do anything but harm you. Well, I've waited 5 minutes. I don't think that's going to get you anywhere. It's not been a litigated point, but the Supreme Court has said simultaneous, real-time discussion. And the other question that stems from this is, again, in your private sector world, you may have teleconferenced. Well, guess what? You can't teleconference under FOIA at local government level. We as the big bad state are allowed to because we're geographically dispersed, our boards, but the premise is that you live in the same place. So unless the governor declares a state of emergency in your locality, you cannot meet by teleconference. It's called electronic communication means, which means it could be text, it could be email, it could be telephone. So just teleconferences are not available to you. It's a prohibition. You cannot do it. There are some limited things. The FOIA Council has actually recommended legislation that is passed that says, this is under the theory of stuff happens. That on the day you plan to come to the meeting, it's a scheduled meeting, or it's a special meeting, emergency, you plan to be there. But something happens, you're sick, you're stuck in the Hampton Roads Bridge Tunnel, you're at work and you can't get away, whatever might have happened to you, or you might be that day of that meeting when you get the schedule in advance, you're in Disneyland with your friends. What you can do then is you're allowed to call in, but the rest of the body has to give you permission to participate by phone. Because we don't want to disenfranchise the people that you represent. And again, under the theory, stuff happens. But you have to get their approval. And you ask, well, why is that? Well, funny, it's always Phyllis Arrigo's calling in going, I can't make it all of a sudden. So it's distribution of the privilege, and the privilege is limited to at most 2 times in a year. So there are times when individuals may participate by phone for personal matters, such as I'm going to be on vacation, I'm going to be on a business trip when that happens, or a personal emergency on the day your child's sick, anything like that will allow. And there's another exception for individuals to participate by phone is if you have a temporary or permanent medical disability. There's no approval required. It just means I'm laid up in the hospital, I can't get there, so you can phone in so that you can fully participate in the meeting. Now the minutes will have to reflect who it was that called in and the nature of the emergency or personal matter. The sickness, you don't have to identify, herpes outbreak or anything like that. Well, it gets real out there. This is the real business. So I just want you to know you have a resource that has the authority to speak to you as well as your county attorneys. We are all very close people and try to do what is right for the right reason. Because this is public services and this is the highest calling, the highest thankless calling, but I'm more than happy that you all threw your hat in the ring. And the comments I get mostly is, this is ridiculous, Maria, this is not convenient. And my response to you, again, in all due respect, is convenience does not belong to the government. Let me say that again. Convenience does not belong to us. And nobody put a gun to anybody's head in this room and said, you must serve. So this is the rules of the road. And your model might have been very different, but public service, like I said, is the most public stage of your life.
An email, I have a question.
Yeah.
An email to the staff, asking the staff to distribute it, then somebody replies to the staff then redistributes it. As long as you're using that staff, that's 100% okay?
That's the way to do it.
Okay, all right.
Yeah, let them moderate your time.
The whole, it can be real time,
Right,
staff.
right.
As long as the staff is always the middle point.
right.
Okay.
Okay. Hi.
Can you comment on the benefits, if there are any, and the dangers in the era of social media and public servants using Facebook to communicate with
Sure.
constituents?
Okay. That's a very good question, and I hope everybody heard about using social media. I have a whole nother talk about why do we use social media, and the answer is if we do it because we think it's cool, is not the good reason for it. But social media, even though it occurs sort of in the internet-based world, is still creating public record. And so the rules still apply. A record that relates to the public business that we have prepared, that we own, that is merely in our possession, and it relates to public business, is a public record that not only can be asked for, but has to be retained. And we have a social media piece on our website for more detail. Yes, sir?
I'd like to ask you a couple of questions about abuse of FOIA.
By whom?
One member of the public submits over 90% of all FOIA requests targeting one department head. This goes on for a long time. At what point does this transition from harassment to public knowledge?
That's a good question. I did say how thankless this job was, right? We've had a number of bills over the years in General Assembly where, somebody is just mad about something that's not even related to their FOIA request.
Yes.
And they're just haranguing. There has been attempts, because FOIA doesn't look at the intent behind the request. It's a right-to-know law. So we've had to try, and as the drafter of FOIA legislation, trying to carve out, well, if you're the harassing person, how do I could stop you, but how do I stop your family members or your friends from doing the same thing on your behalf? It's a tough law to write, and we don't want to go down the road of saying, of divining intent, that these are too many, or this is, you're trying to harass us. Now, FOIA does give you tools, which is, if the FOIA request, the search alone, or just the volume of records requested is such that it interferes with the operational responsibilities, you can petition circuit court for more time. I think when it's the same requester asking for the same records, which is a rare occasion, that, I apply the rule of three. You put a chronology. You ask for this on this date, we provided it. You ask for this again on this date, we provided. You ask for this time, we've provided all the records, that's it, we're not doing any more. Again, write every letter with the mind that a judge is reading that. And if it's full of a bunch of attitude, the judge is not going to look favorably upon you. But there's not much other than try to work a deal. I suggest some of the more practical, bring that person in, give them an airing, let them, meet with staff. I know it's nothing, some people, my yaya, of Greek descent, my yaya, the translation is, I can't break my head to fix yours. And so, but some people just want to have a form to blow. And if you provide that, they may go away. These are just constructive human recognition of human things. But other than petitioning circuit court, unless it's the same request for the same records, I think after 3, you give the chronology, we've done it, we're done.
Follow-up question to that.
Okay.
If you have people asking for FOIA requests who haven't paid their taxes, personal property taxes, and everything else in years, can we deny those requests?
No.
It's a shame.
Now, what FOIA, one of the tools you can do, one of the tools that FOIA gives you is that if somebody, because if they're behind on their taxes, then they're probably behind on not paying you for the records.
Oh, no, they're paying for those.
They're paying for those? Yeah, because FOIA says if anybody's more than 30 days in arrears from payment of a FOIA charge, but that might be something to talk to your legislator about. See what I told you about FOIA?
One more question.
I'll stick around.
Can't you send them a bill that for your time and everything?
Yeah, FOIA, you can certainly charge, and that's the one thing the citizens don't get, is that this is, God bless the Commonwealth, the pay-as-you-go state, and there are charges that you may impose. Again, must be reasonable, and it's cost recovery, not revenue generation. Okay? One more, yes, sir.
You didn't touch on subsection B, which specifically...
Of what?
FOIA requests. A contractor sends information to one board member concerning what he can do for the county or for whatever entity it is. That, according to your FOIA request, is FOIA-able, or whatever your word is, for that. And that is not, that's still just the two people. But it is a communication from a contractor back to one of the committee members.
Okay, but there's a distinction here. On the meeting side of FOIA, discussions among 3 or more of the full body is a meeting. That's a separate issue. On the record side of the ledger, anything that you own, that you've prepared, or merely in your possession as it relates to the transaction of public business. So when contractors email you, or your constituents email you, or the school board may email you, that is still a public record. So it's a different, meetings is among the body. The record is anything that records, reflects transaction of public business. Okay?
And I just want to comment on that. That may give rise to some conflict of interest issues, some ethics in public contracting issues. That's a real slippery slope, that kind of thing, depending on what the content of that communication is. We have to cut it off now because we have many other topics to deal with, but I will say in your materials, in your pocket, you'll find a little pamphlet. It's got Maria's contact information, Alan Bernhardt, her assistant, his contact information, the Library of Virginia, and mine, so that you can always get in touch with us when you have a question. Maria's going to stay for a few minutes to answer questions, and I want to thank her for taking her time to be with you this morning. And give her a round of applause.